and then I'm going to start the, yeah, I guess the webinar has started, right, Matt? So we're just going to start the stream and that will go live. So
let me know when, Marcus.
All right, 5, 4, 3, and you'll see a window in a minute.
Okay.
Yep.
All right. Good afternoon, everyone. Welcome to the last workshop of our conference, Unraveling Subsidized Housing Law. So I hope you've all enjoyed our conference so far. We're here at the end of the road of 3 days, which has been a great 3 days. Keep in mind that there will be a code for you at the end that you can use for CEUs and to continue playing the Cohio game. I'm Joe Muscoviak. I work with for Cohio. I'm here to introduce and moderate our speaker, Nick DiNardo. Let me tell you a little bit about Nick. Nick began working for the Legal Aid Society of Greater Cincinnati in 1998. After graduating from the University of Cincinnati's College of Law, where he was an Arthur Russell Morgan Fellow. He has worked as a staff attorney for the Housing and Consumer Practice Group and the Income Work and Health Practice Group. He was promoted to senior attorney in 2003 and to the Housing Practice Group manager in 2006. I have a hard time believing it's been that long, Nick.
Me too.
Nick frequently lectures and conducts CLEs. Those are CEUs for lawyers on Ohio landlord-tenant law and federal subsidized housing law. He serves on the board of directors for Over the Rhine Community Housing, a nonprofit low-income housing provider, and not just any nonprofit low-income housing provider, but one that is on the Ohio board. So Nick is both a colleague and a friend of mine, going way back, as you could just tell from those dates. So are you ready to take it away, Nick?
After an intro like that, yeah, I guess so.
So I should say, sorry, go back. This is a little bit about Cohio. You guys have probably, if you've been attending the conference, you're tired of seeing the screen about what Cohio is all about. So I'm just gonna not talk much about it and go right through to the next slide, talking about, again, stuff that we've repeated over and over and over again. Do we need, I don't think we need to repeat this all, Marcus. We're at the end of the show here. So
Go ahead, Joe.
Yes, we are recording.
Proceed.
Yes, you will have the PowerPoint after. So I'm sorry, Marcus.
I said, go ahead, Joe, proceed.
Okay, then let's turn it over to Nick, and he can start unraveling subsidized housing law for us.
So thank you, Joe, for the kind introduction, mentioning how old I was at least 3, maybe 4 times. That's great. I'm still younger than you and will always be. So yes, my name is Nick DiNardo. I'm the managing attorney for our housing work here in Cincinnati. We've got basically 7 counties in Southwest Ohio that we provide legal services for. And I've done this similar presentation for the past couple of years at Cohio. So this is going to be kind of a basic introduction to subsidized housing law. So it's not going to be about evictions or that sort of thing, but I'm happy to answer any questions you have about the eviction process or anything else, or landlord-tenant law generally, that might come up during the presentation. And in fact, I don't want to just lecture for an hour and 15 minutes or however long we have for the session. So please feel free to add questions into the question and answer box. I hope that's right. And Joe is going to interrupt me with any questions that come up. That way you won't be bored, and frankly, I won't be bored either if I just sit here and talk the whole time. So please ask questions as I go along. I think you can go to the next slide. All right, so we're going to cover a couple of different things. One, we're going to look at kind of the basics of subsidized housing law, how it works, you know, how rents are determined, how the apartment size is determined, those sorts of things. We're going to talk about the different types of subsidized housing. Again, it's just going to be an overview, but for those on this call or Zoom meeting, whatever we have here, that are a little new to this area, I want to kind of break this down because there's different rules for different types of subsidized housing. And so it's really important when you're advocating for your clients or when you're working in this field in one way or another to kind of know what type of housing it is if you're dealing with an individual situation. Do a little bit about rents and utility allowances, how to apply for subsidized housing, and what happens if you get denied, what the rights are for tenants in that situation. And lastly, we're just going to go over kind of the basics about subsidy terminations or evictions from subsidized housing, focusing mostly on kind of federal housing law and what the tenants' rights and responsibilities are. Okay, next slide. All right, looks like I've already said half these things. Joe's apparently listening in and moving the slides along. So if I get something wrong, he may buzz in. But we'll just kind of cover some of these basics to give you a general understanding about how this works. All right, next slide. Okay, I'm probably preaching to the choir here, but it's important to understand why subsidized housing is important. You know, the average SSI recipient is going to be poor for the rest of their life. And so if they're in a subsidized unit, based on what the SSI monthly benefit is, they're going to pay about $160 a month for rent. Fair market rent for a 1-bedroom in Ohio, I think this is the 2021 data, is $684 a month. And I can tell you in urban areas, it's probably a lot more than that. I think in greater Cincinnati, it would be difficult to find a 1-bedroom that was in any kind of decent shape for $684 a month. So that just shows you that gap between $160 a month and $684 is why subsidized housing is so important, whether it's a disabled family or whether it's a family with kids with a kind of living paycheck to paycheck. It really is of crucial importance for family kind of stability. Okay, this next bullet point we're looking at here is just for Hamilton County. I probably should be a little bit more specific about that, but I wanted to just give people some rough idea about what the gap is in affordable housing. Right now, in terms of public housing, project-based Section 8, housing choice vouchers, we've got about 20,000 subsidized units in Hamilton County, and there are 100,000 families who are eligible for subsidized housing in Hamilton County. So what does that mean? That means 4 out of 5 low-income people are paying far more rent than they can afford just to get by. So it's a really critical thing that we need to look at, not just helping people stay in subsidized housing and preserving what subsidized housing we have, but developing more, because the need out there is great and the supply is pretty minimal at this point. All right, so the next bullet point deals with something called the housing wage. And this is generally what a family would need to be paid per hour at a full-time job to afford a 2-bedroom apartment. I think this is 2021 data. I updated this, but it's $16.50 an hour working full-time to afford your average 2-bedroom apartment in Ohio. I know most of my clients who I'm representing are not making $16.50 an hour. And if they are, they're probably not getting full-time hours. They're probably working some kind of a more part-time job or stringing together a couple of part-time jobs. So with one working member of the household, it's, for most of our clients, it's really difficult to afford even a 2-bedroom apartment. Lastly, subsidized housing is really important because if you're in it and you lose it, getting another subsidized unit is very difficult. Probably won't happen at all for a few years and may not happen ever again. So when we do get a family into subsidized housing, it's really important that that's protected to help them maintain some stability. Okay, next slide. All right, these are just the absolute basics of how subsidized housing works. There's some nuances here that we're not going to get into for the purposes of this presentation, but I just want to give you a kind of a general idea about how it functions. So tenants pay 30% of their income for rent and utilities. And I'll have an example in a couple of slides that goes through this, but that's the general rule, is we want their rent and utilities to be 30% of gross household income. They do use the gross income for these calculations. Oftentimes my clients will say, well, I might be making $1,000 a week, but I'm only bringing home 700. It's that $1,000 amount that, or probably not a week, but probably a month. But that's what is used to determine the 30% of income. It's always gross income, much to our clients' chagrin. The size of the unit you get is not based on how much you pay for it. It's based on the amount of people in the household. There's some kind of general rules on this. There's a lot of discretion for different subsidized housing providers, but the size does not affect the amount of rent. It's only determined by the number of people in the household. The way this works is once the tenant pays 30% of their income in rent, generally there is some sort of a subsidy paid to the landlord one way or another that covers the rest of the rent for that unit, which is often referred to as the contract rent. If the tenant resides in subsidized housing, the landlord is subject to federal law, which generally has some additional requirements that the landlord has to follow, whether they're a public housing authority, a project-based Section 8 private owner, or the owner of a private unit where the person has a voucher. Lastly, the tenants have many additional rights in subsidized housing, but they also have many more obligations, such as reporting income and reporting household composition and those sorts of things. So there's a lot of things that tenants need to do when they are in subsidized housing. All right, Joe, how am I doing on questions? Any questions yet?
Not yet, Nick.
Okay,
So
come on, people, help me out here. All right, next slide.
I will kibitz shortly if necessary.
Okay, good. All right, I already talked about this or touched on this a little bit. There are 4 basic types of subsidized housing. The first one I'm going to talk about is what's called public housing. Now, this is a term of art. Public housing means a specific kind of subsidized housing. It's owned by a public housing authority. So it could be one of the many CMHAs in the state of Ohio, Cincinnati Metropolitan Housing Authority, Columbus, Cleveland Metropolitan Housing Authority. We also have Claremont Metropolitan Housing Authority in my area. So it has to be owned by a public housing authority. That public housing authority, or PHA is the acronym there, they receive funding from HUD to provide and maintain this housing. And that's not exactly accurate because frankly, HUD does not give them enough money to maintain the housing. And we'll touch on that in a minute. But the money comes directly from HUD. The PHA gets a budget to run their public housing units. This is what's called a unit-based subsidy. And what that means is the subsidy stays with that individual unit. So if the family moves into the apartment, they get the subsidy. They only have to pay 30% of their income in rent. But if they move out of that public housing unit, they don't get to take it with them. It goes to the next family who moves into that unit. Public housing requires good cause to terminate a tenancy. I've got that in quotes there because there's kind of a specific definition of what that is, and I think I'm going to cover that later on in the presentation. But what this means is the landlord must have a reason to terminate the tenancy, and it must be a good reason. A landlord cannot just give the tenant a notice they want to end the lease or end the month-to-month tenancy for no reason. The last thing on this slide is something called the RAD process. RAD stands for Rental Assistance Demonstration Program or something like that. I think that's right. It's no longer a demonstration program. It maybe started out that way, but now much of the public housing in this country is being converted through the RAD process. What this generally does is it takes a public housing building and changes the subsidy type, generally speaking, to a project-based Section 8 subsidy. We get really into the weeds here, which I'm sure Joe wants to do right now. I'm not going to do that. But what it does is it changes the public housing into some sort of project-based Section 8. The reason for this is because over the past, 40, 50 years, HUD has not provided housing authorities with enough funding to maintain and redevelop the housing as it ages. A lot of the public housing in this country was built in the 40s, 50s, and is now aging pretty rapidly. And HUD has never provided enough money to maintain that housing. So what this RAD process does is it allows public housing to be rehabbed or redeveloped in some way using some private financing, which they couldn't do before with public housing. So it does allow them to get some new money into the public housing buildings to help maintain them and rehabilitate them. The problem is we don't know what happens if something goes wrong. Like if a public housing authority defaults on that debt, or if there's some other, kind of issue. So that remains to be seen. I think different jurisdictions have had different results with the RAD process. It's been pretty good in some jurisdictions. It hasn't worked so well in other ones where tenants were displaced, not allowed to return to their original units, or there were kind of other issues with relocation and kind of net loss of units. So this is what the future of subsidized housing probably looks like, there with some good points and some bad points. But so you may hear about RAD as you're talking to people dealing with subsidized housing. And that's the kind of the main thing to keep in mind, because it's a process for rehabbing public housing, but it does change the type of subsidy associated with that building. All right, it looks like, Joe, are you gonna do these questions, or do you want me to?
Nick, I thought the first question I was going to wait till the end. That sounds like a question at the end. The other one just got posted.
Okay, so I'm going to keep going, and you're going to interrupt me if one of these questions is if it meets your high standard of appropriateness.
No, I already know where I'm going to ask this question.
Okay.
Well, here's a overall, is RAD good or for affordable housing, or bad?
Well, that's hard. I think it's a bit of a mixed bag, as I just said, of what other people think.
Well, I agree with you. It is a mixed bag. So, I mean, tenants lose a lot of rights that they have associated with public housing. On the other hand, it's a way for public housing to be able to upgrade their stock and be able to provide safe, affordable housing that they might otherwise have to demolition, which has happened in a lot of places, more outside of Ohio than inside of Ohio. So it's a double-edged sword, in my opinion.
Yeah, I think the bottom line is it's the future, whether we like it or not. So there's going to be some advocacy needed around it to make sure it's done in an equitable way.
Yep, I agree.
I thought I heard another voice there too. Or is that just in my head?
I think it's in your head.
Awesome. Okay. You want to go back to the slides?
Yes.
I'm not seeing them. There we go. All right, I think we covered that slide. Why don't you go to the next slide? Okay, the next type of subsidized housing that I want to talk about is what's called project-based Section 8. Now, this is sort of actually a catch-all name. There are kind of multiple different kinds of programs in project-based Section 8, but generally speaking, it's kind of one model. And there's one set of regs that generally apply to most of it. That's just lawyer talk for, I'm giving a very general overview of it here. All right, so project-based Section 8 is very similar to public housing in that it is a unit-based subsidy. So if a family moves into this, into a project-based Section 8 apartment, their rent is based on 30% of their income. And if they move out, the subsidy stays with that unit. They don't get to take it with them. The main difference is that it's privately owned. So instead of being owned by a public housing authority, it's owned by a local developer who may be nonprofit or for-profit, but has a contract with HUD to provide rent subsidies and to maintain the building kind of under the project-based Section 8 rules. Similar to public housing, it requires good cause to terminate the tenancy. And while we don't see this very much with public housing authorities in my area, we see this all the time with project-based Section 8 landlords who think they can just give a tenant a 30-day notice to end the month-to-month tenancy, or can refuse to renew somebody's lease for no reason. That's not the case. With project-based Section 8, you have to have good cause to terminate a tenancy. Okay, so I think that's probably all for project-based Section 8. You got anything else, Joe?
No.
Okay.
I will interject after you do the next slide.
Got it. All right, next slide, please. Okay, there's something else, a different kind of subsidy called a housing choice, formerly known as Section 8 vouchers. Now, this sounds similar to project-based Section 8, but it's very different. A housing choice voucher is a tenant-based assistance, meaning that the tenant moves into a unit if with their voucher, they pay 30% of their income in rent. And if they move out of that unit, generally speaking, they take that voucher with them to their next unit. So it's a very different kind of subsidy. To make things even more confusing, the housing choice voucher program is usually run by your public housing authority. So your local public housing authority has both public housing units and runs a voucher program, but those are two different and very different types of subsidies. The way a voucher works is they'll take the voucher to any private landlord who will accept it. And once they do that, if the landlord and the housing authority can agree on a rent, then the tenant moves in. They pay 30% of their income in rent, and the balance of the contract rent is paid by the local housing authority directly to the landlord. There is a lease addendum that they must sign that goes with the lease that the tenant signs with the landlord. And it just has kind of some basic rules and obligations of both the landlord and tenant when a housing choice voucher is used. There's also separately a contract between the landlord and the housing authority called the Housing Assistance Payment, or HAP contract. You'll see that acronym a lot. And so it's kind of a three-way relationship here when a tenant is using a housing choice voucher. Local housing authorities must set what is called HUD sets rent reasonableness based on geographic areas, and the housing authority does have some discretion to adjust those rent reasonableness amounts, but I don't want to get too far into the weeds on that. What I can tell you is, generally speaking, there is a maximum rent per bedroom size that the local housing authority will set. And so as long as the landlord's rent is at or below that amount, the person can use, or if the landlord's willing to reduce whatever rent they're asking for to that amount, the tenant can use the voucher there, but they have to meet the rent reasonableness guidelines for the contract rent. Units must pass something called housing quality standards, or HQS. What this means is that once the tenant places their voucher, or is in the process of trying to place their voucher with a private landlord, generally the housing authority, or possibly some agency or some person they contract with, has to go out and inspect that unit to make sure it meets these minimal requirements. So there is an inspection. If the landlord passes the inspection, then they can enter into the HAP contract with the local housing authority. These are supposed to be kind of the floor. So it doesn't mean kind of the most basic requirements. So it doesn't have to be a super nice place. It doesn't have to have a jacuzzi tub or even a dishwasher for that matter, but it does have to meet some fairly basic requirements in terms of health and safety. Another quirk of the housing choice voucher program that is not in the previous two programs is that tenants have the option to pay up to 40% of their income in this program to rent a nicer apartment. So if the landlord is asking for more rent than the rent reasonableness standard, or if the rent increases, in the following years after a tenant first moves in, they can agree to pay up to 40% of their income to cover that additional amount. I don't always recommend this because it can end up being sort of a trap for tenants who are paying more rent than they can really afford on a place. But in some instances, it does allow tenants to stay in the home that they've been in for many years, or it may help them stay in a school district their kids are in. It's a better school district. So that is a possibility for housing choice vouchers, where you can actually pay more of your income to rent a more expensive apartment. One thing about the housing choice voucher program is that while there is technically a good cause requirement and the housing authority must have good cause to terminate the voucher, the regular landlord-tenant law applies between the landlord and the tenant. So that once the tenant's lease is up, the landlord can decide if they want to renew the lease or not, and and if they decide they don't want to, they don't need good cause to renew the lease of a housing choice voucher tenant. So I know that's a little confusing, but so that's the good cause requirement for a housing choice voucher tenant, I would say, is not quite as strong as it is for other types of subsidized housing. All right, Joe, you want to go to the next screen?
Sure, go ahead, but
Okay.
I'm going to interject here. So I know that there is still more private landlords on this screen, but we've already talked about two different types of private landlords within subsidized. And the question is, so does a private landlord who has a tenant being subsidized by a federal program have to follow VAWA, or the Violence Against Women Act?
Yes, I don't think I did a separate slide on VAWA, but I can talk about it a little bit. And frankly, Joe, you might have more expertise than me. But the general rule is that almost every type of subsidized housing is now covered by VAWA, the Violence Against Women Act, which gives some protection to victims of domestic violence, stalking, and other forms of severe harassment. Originally, when VAWA was first passed, it didn't apply to all kinds of subsidized housing. Then there were some amendments, and so now I'm pretty sure it applies to everything. I may be a little off on that, but at a minimum, it applies to about 99% of subsidized housing, and that includes housing choice vouchers. So you may have a private kind of mom and pop landlord who's renting to someone with a housing choice voucher, and that tenant does have VAWA protections.
Yeah, so, and you're right, Nick. They actually just passed VAWA, the newest act, and it expanded yet again programs that are covered by VAWA. It keeps growing with each passage. So that is correct.
Yeah, and without going in, oh, go ahead, Joe.
No, if you had something to add, go ahead, because I was going to ask another question.
I was just going to say, so with VAWA, that generally just gives tenants some additional protections in terms of rights to or options to transfer, other types of things that can be done to protect them and protect their tenancies. So didn't really prepare anything to address that today, but it really is a useful statute that can really help people in subsidized housing during that situation.
The two biggest protections, in my opinion, is you cannot deny somebody because they were a victim of domestic violence, and you can't terminate them for that reason either.
Yeah, that's a great point.
Now,
but just to be clear, VAWA only applies to subsidized housing. If someone is just in purely private housing, the protections do not apply to them.
So the other thing you mentioned, Nick, with the voucher program was the mandatory HUD addendum, lease addendum?
Yes.
If there is a conflict between the landlord's lease and the addendum, they say things that can't possibly be reconciled, which one wins?
The addendum does, Joe. There's actually language in the addendum and in federal regulation that says that you can put whatever terms you want in the lease, but that if there is a conflict, the addendum controls. Where we see this most often is if a landlord fails HQS inspection after the tenant's already living there. So the roof's leaking, the landlord's not fixing it, the tenant reports it to the landlord and nothing happens. So they report it to the housing authority, and the housing authority comes out. And if the landlord doesn't make prompt repairs, then the housing authority can abate the housing assistance payments, meaning they hold them back, and the landlord doesn't start getting paid again until they complete the repairs. Some we see leases where it will say, if CMHA doesn't pay, it's responsible for the full amount or something like that. And the addendum is very clear that the tenant is only responsible for their share of the rent, and that if any rent is abated or not paid timely by the housing authority for whatever reason, that's between the housing authority and the landlord. The tenant's not responsible for any amounts that are held back or not paid for some reason.
Okay, great example, Nick. Okay, let's move on.
Okay. The fourth type of subsidized housing is not really a type, but it's a kind of a catch-all category that I kind of call everything else. So these are some other programs that provide different types of subsidized housing that you kind of may hear about. One is the Rural Development Program. This is not run by HUD at all. It's actually run by the Department of Agriculture, but it looks a lot like project-based Section 8. And so you may see this if you're in out in the rural counties. there's not much of a difference. Rent is generally calculated the same way. The only real difference between RD and project-based Section 8 is that there's a lot of regs that HUD has promulgated for project-based Section 8, and rural development doesn't have any of that. So oftentimes when we are representing a rural development tenant in a court case, we're usually citing to the project-based regs and say these don't control, but this should give you a good idea, Judge, about how you should treat people in rural development. One thing we're seeing with rural development is there's also a process where some of that is being converted into project-based Section 8, because frankly, the Department of Agriculture, it's not really their expertise to run housing. I suspect that's where rural development will go in the future. It will be phased out at some point. But for now, you may see people with that type of subsidy, but it's very similar to project-based Section 8.
So Nick, a question popped up about the voucher program after we got done with that, but I think it's
Okay.
still a good time. So the question is, if the tenant wants to pay up to 40% of their income, does the unit still need to meet rent reasonableness? This question relates to the housing choice vouchers, as I just said.
So this gets super messy, and I could probably show you with an example if I had to, but unfortunately, one of the examples I have coming up doesn't deal with this. The general answer is yes. So for example, I guess what I would say is if a housing authority says the most we'll pay for a 2-bedroom apartment is $1,000, and the tenant's making $1,000 a month, so their share of the rent's $300, but the landlord wants $1,050. Assuming my math is right, I'm not sure it is, but that tenant could agree to pay that additional $50, so more than the rent reasonableness amount, to either rent or stay in that unit, as long as the tenant payment is below 40% of their income. So I hope the math works in that example. I'm not sure if it does or not. But so yes, they can pay more than the rent reasonableness maximum amount, but they're still stuck with that 40% calculation.
So I'm not one to check or correct your math, that's for sure. But that made me think of a similar question. So what if the landlord can't get what they want from the housing authority and tells the tenant, well, I'll let you live here, but on the side, I need you to pay an extra $100 between you and me?
So this is very common, and it's a huge no-no. That's a violation of one of the tenant duties under the Housing Choice Voucher Program, is that they may not make any kind of side or under the table payments. And sometimes landlords will just flat out ask for the difference, and they can't do that. The tenant can have their voucher terminated for doing that. Sometimes the landlords will get creative and they'll have a parking fee or a garage fee or a refrigerator rental fee or something like that. If it's a fee they charge to all tenants, then they can probably charge that fee to be part of the rent calculation. However, if it's a fee that they only charge one tenant in order to facilitate what is, for all intents and purposes, a side payment, that is not allowed. So the landlord would be violating the contract that they signed with HUD, with the housing authority, and the tenant would be violating their duties if they make those payments. That being said, it happens a lot. Some housing authorities, Cincinnati Metropolitan Housing Authority, cracked down on that a few years ago, so we see it less, but it's still pretty common that we see it. And sometimes it's even the tenant's idea, because tenants are desperate, and it's really hard to place housing choice vouchers these days. And so they may just tell the landlord, hey, if this won't pass, I'll just pay in cash each month on the table because I really need to rent this place because I'm desperate. So it's not always an abuse of power or fraud. Sometimes it just shows that our subsidized housing system may not be keeping up with the market forces in an area. But the rule is no side payments.
Thanks, Nick. Here's something else that came up. I think this person probably didn't hear either of us correctly, but I'm not sure. They said, I'm sorry, I'm not a professional, but we have claimed that this for a few of our clients, VAWA does cover all Section 8 and HUD housing. And if you look at VAWA, I don't think that's any different than what you and I have already said, in my opinion.
I think that's right. Yes, VAWA covers, as far as I know, I can't think of any type of subsidized housing it does not cover. So basically, I think you can rest assured that VAWA covers all types of subsidized housing. It's just during its history, that wasn't always the case. When VAWA first started, it only covered a few certain types of subsidized housing. Now it's clear that it covers basically every program I'm aware of.
Agreed. If it's in a HUD program, you should assume VAWA applies.
Yeah. Well, maybe this is a good segue into my next little bullet point here. I just talked about rural development. There's something that many of you either know about or may have heard of called low-income housing tax credits, or some people pronounce that acronym LIHTC. This is a way to finance either the rehabilitation or the new construction of affordable housing. And frankly, it's pretty much the only game in town when it comes to developing new affordable housing. What LIHTC does is have some of the protections of other types of subsidized housing, but it is not a unit-based or income, I'm sorry, it is not an income-based subsidy. So the way LIHTC works is rents have to be below a market, below a specific kind of market rate housing, but it's not adjusted based on the tenant's income. So if the market rate for a 2-bedroom apartment is $1,000, the LIHTC property that's developed using this program may rent the 2-bedroom for $800 a month, but the tenant's rent is not based on their income. So it's not as good from a tenant's point of view as being in a public housing or project-based Section 8 unit. However, it's better than nothing, and this is what the future of affordable housing in our communities look like, at least for the next many years. So the other good thing about the LIHTC program is they're required to accept tenants with housing choice vouchers. So if a tenant has their own voucher, they can apply to a LIHTC property as long as they otherwise meet the requirements. The LIHTC property cannot refuse to take someone with a voucher. So that's a nice thing. And not all LIHTC landlords know this. So we oftentimes have cases involving that where someone said, a LIHTC landlord, maybe the project was developed 10 years ago. There's a new management company who doesn't really know anything about LIHTC. And we'll actually get letters saying, oh, we don't take housing choice vouchers. They don't have that option. If there's an active LIHTC restriction on the property, then they must take housing choice vouchers. That's probably all I'm going to say about LIHTC. Joe, did I miss anything big that you want to throw in with that?
Sure, I'll ask a question. Does a LIHTC housing provider have to have good cause to terminate?
Yes, Joe, that's an excellent question. And in fact, they do. There is a requirement in Ohio, which I think is an Ohio specific requirement, of a separate lease addendum for LIHTC properties that basically says that there must be good cause to terminate that tenancy. So even though it looks like a regular kind of private landlord-tenant relationship, the landlord still must have good cause to terminate that tenancy, whether or not they have a housing choice voucher or anything else. LIHTCs do require good cause. Excellent point, Joe.
And we just had another LIHTC question come up. Will undocumented families qualify for LIHTC properties?
I should know the answer to this, and I don't know off the top of my head. It can definitely be an issue for other types, for project-based Section 8, public housing. You can have what are called, and this is the term that HUD uses, so please don't flame me in the comment section, but then you can have what's called a mixed household. So you can have, mom and dad may be undocumented, but they may have 2 U.S. citizen children, who are born here. So if that's the case, they can actually get half the subsidy because 2 out of 4 people in the household are documented. And so they can still get some benefit from subsidized housing, but not the full benefit. With LIHTC, do you know the answer to that, Joe? I'm actually not sure. I'd have to look it up.
I'm with you. I'm not sure. I'm almost certain the answer is yes, under the same kinds of rubric, but I'm not absolutely certain.
Yeah, I don't know the answer. Part of the problem is that tenants in subsidized housing, including LIHTC properties, have to recertify every year with income and household composition. And so oftentimes a lot of folks who are undocumented are not, either don't want to provide that information or are not going to have things that are asked for, like, social security numbers, or maybe they're working under someone else's social security number, those kind of situations. So, we don't see that a lot oftentimes because I think they sort of self-select themselves out of that type of landlord-tenant relationship. But I'd have to double check that. I can't say for sure.
Someone opined that LIHTC does not look at citizenship. Again, I'm not sure.
I'm just not, I'd have to look it up. I'm not sure either. Okay,
There's
can I
another
move on
question.
from LIHTC, Joe?
No, another LIHTC question.
Okay,
Hold on. Just they're pouring in now. You asked for this.
yeah, I know. Well, it's better than me just prattling on and
I
on.
agree. Where can one find a list of the active LIHTC properties with the date they become inactive?
So that's a good question. And that is from, I think, fellow Cincinnatian Debbie Greenebaum, who I talk to from time to time. I should have this in my presentation, and I do not. But there is something that the low-income housing, wait a second. There's something called the Preservation Database. Who runs that, Joe?
Yeah, there's the Ohio Preservation Compact. So
That's not right. I look in the Federal Preservation Database. It is run by the.
But I don't think the Federal Preservation Database includes LIHTC. I'm not sure.
Oh, I think it does.
Does it? Because
Yeah, I'm not sure how quickly it's updated.
Right. The Ohio Preservation Compact definitely does. However, it has not been maintained recently. So regarding the dates, especially the dates that may or may not have ended, may not be accurate.
So here,
looking at contracting out to update that database. That hasn't happened yet to the best of my knowledge.
so the way I do it is you can get, if you're any kind of nonprofit or housing provider, I think you can get a free login to the National Preservation Database. I'll try and put this, or maybe Joe can put it in the chat box or something, but the website is preservationdatabase.org. So it's all one word, preservationdatabase.org. I think you get a free login. It's run kind of like an Excel spreadsheet, and you can search by address, you can search by project name. Sometimes you can, what I usually do is search by zip code so that I can find the project, because sometimes there's multiple addresses associated with the project. But I find that to be pretty complete and pretty useful. And so that's how I often check, because frankly, you can lose track of these. The restrictions on a LIHTC property can be as short as 15 years, but are generally 30 years for most of the LIHTC projects that have happened in the past, have happened recently, and are funded going forward. So what that means is all these restrictions about how much the rents can be and about accepting vouchers and good cause go on for 30 years, after the LIHTC funds go into that project. So sometimes
there was a link posted, Nick, for the database that you just.
Okay, brilliant. Yeah, I love that database. I think it's really it's well maintained, and it seems to be pretty accurate in my experience.
Here's a fun question.
All right.
When clients put their rent in escrow or ask for a complaint inspection, they are always terminated, at least in my experience, as soon as the lease is up. How is it worth it to get to court or get the housing authority involved? What can they do to get their units fixed up?
There's a huge problem that we see all the time. Retaliation is illegal both under federal law and in Ohio landlord-tenant law. So a landlord is not allowed to either threaten or file an eviction or terminate a tenancy because the person has asked for repairs, or they've tried to do tenant organizing, or that sort of thing, or it made any claim for the under tenant basic tenants' rights. In Ohio, the rule is that any adverse action within 6 months is presumed to be retaliatory. But the reality is tenants get evicted or have their leases not renewed for this kind of thing all the time. And the only way a tenant can defend themselves is to defend the case in court, which isn't a very good form for most tenants to defend themselves in unless they have a legal aid attorney. And we have very limited resources, so we can only take so many evictions per month. So the answer to this question is start with the nicest kind of advocacy with the landlord. Try and ask for repairs to be made, kind of put stuff in writing just to document what repairs are being asked for. But I oftentimes have to advise my clients, keep in mind that if you call the building department or if you call the housing authority to do an inspection, this may end down the road with you having to move. And so you got to think about what's more important to you, getting this leaky faucet fixed or maintaining your affordable housing. And it's not fair, but that's the reality for a lot of our clients. And in fact, when we have new attorneys or new paras who start paralegals who start in my office, we oftentimes have to kind of have this talk with them. Like the client needs to decide what's best for them. And that's not always complaining about the conditions. And that's not right, but that's the reality is that's what a lot of tenants face on a day-to-day kind of basis.
I would emphasize that despite the capacity limitations that you mentioned of your organization and others, getting a legal aid attorney still should be the first thought. It comes down to that, because you're much better served with one than without. A corollary question just came up on the escrow. Does a tenant have the legal right to terminate their lease if a landlord refuses to fix the unit?
That's a tricky question because the general answer is no. What under Ohio law, what the tenant can do is they can begin the rent escrow process, and then they can ask the court to terminate a pending lease. So tenants, they're taking a big risk if they just say, landlord, you're in breach, I'm moving out. So it depends on your tolerance for risk, but if you're a tenant, the best thing to do if you're in the middle of a lease and your landlord won't make repairs is to escrow the rent. And if your goal is to move before the lease ends, and then ask the court to declare that the tenancy is over. That's the only surefire way to do that. Now, if you're a month-to-month tenant, or if you're nearing the end of your lease, you can simply give the landlord a 30-day notice saying, I'm not going to continue this month-to-month tenancy, or I don't want to renew my lease at the end of the next month, and then you can move that way. But it can be a tricky situation for tenants when the landlord's not making repairs and they're in the middle of a lease.
I would just add, Nick, that you certainly under the statute can terminate without going to court. But like you said, going to court to get the court's imprimatur, their permission, is by far the best approach.
Yeah. All right. Anything else on the question side, Joe?
The question is, what is the break lease letter for them? I think I just answered that question.
You can put that. I mean, here's what I would say. You can send your landlord a letter saying that you're not making repairs, so I'm finding you in breach of this lease and I'm going to move out. Excuse me. Press up my phone. Joys of Zoom meetings. But if you do that, you run the risk of the landlord suing you for the balance of the rent left on the lease. And in my experience, particularly in Hamilton County, where Cincinnati is, if you don't escrow your rent and try and take that approach and don't have a good attorney with you in court as the tenant, you're probably going to lose. It's pretty hard to win that case or defend that case. So my advice is, if a tenant wants to terminate the tenancy in the middle of a lease for a landlord not making repairs, they should follow the rent escrow process. It's the safest way to do it. And one thing I would say, I don't want people to think I'm all anti-landlord and or anti-courts or anti-judges. But in my experience, when tenants do escrow their rent, follow that process, most of the courts seem to be fairly responsive to the tenants' complaints. That may not be the case in every single court in Ohio, but where I think the eviction process is definitely slanted towards landlords, I feel like the rent escrow process, tenants oftentimes seem to get a more fair shake to be.
All right, we need to move on. We haven't gotten very far. You've gotten your wish with a lot of questions.
All right. Let's see. Oh, I didn't cover this last thing. There's several other kinds of subsidized housing. I won't get into them right now, but a lot of times there's, some of the homeless prevention dollars will run different kinds of housing subsidies, rapid rehousing, shelter diversion, some of those kinds of things. Also, I think there's some programs for folks with disabilities who get some kind of housing subsidy. Those are generally, they're not coming through the housing part of HUD and may come from totally different areas, but you may see some of those as well. Some may have income-based rents. Some others may just have rents that are set at a below market rate. All right, next slide. Okay, rent and utility allowances. I get a lot of questions about these issues from service providers like many of the people who are on this Zoom meeting. So I want to kind of go over some of the basics here just so you have a general understanding about how this works. So tenants must do something called an annual recertification. And what that is, annually, either on their anniversary date or on another specific date kind of set by the subsidized landlord, they have to come into the management office, or now in the world of COVID, They can do a lot of the stuff virtually or by mail, but they have to report what the total household income is and also the household composition. So how much the gross amount the household's bringing in every month and how many people live there. Usually it's the same month every year. Sometimes it gets switched around, but that's something that's required of all subsidized housing tenants. You must do an annual recertification. There's something else called an interim recertification. Now, this is something that is utilized by the tenants if their income or household composition changes during the year. So if the tenant's income increases, they may have to report this to the Public Housing Authority, and they may increase the tenant's portion. And the reason why I keep saying may is because that's a lawyer word, which means the housing authority is not required to do this. But generally speaking, the tenants are going to need to report any changes in income and then leave it up to the housing authority whether or not they're going to adjust the rent or not. That's for income increases. For income decreases, the tenant has the right to request an interim recertification and decrease the rent. So if the tenant was working, then loses their job due to COVID, let's say, they can immediately report that to the Public Housing Authority or project-based Section 8 landlord, and their rent should be adjusted to 30% of their income. And if their income is zero, their rent should go down to zero until they find new employment. But those are just two kind of key terms to keep in mind, both annual and interim recertifications. All right, next slide. All right, so I've already covered some of this stuff. The tenant share is based on 30% of the household income. There are a bunch of deductions for dependents in the household and for medical expenses and all kinds of other things, but the general rule is 30%. The tenant share includes rent and utilities. The reason why they have this rule is because they want to be able to compare apples to apples, so that a tenant who has an apartment where all utilities are included is paying the same amount of their household income as a tenant who rents a place where none of the utilities are included and they have to pay for those separately. So we want those two families in subsidized housing to be kind of treated the same. I got a couple of examples that are coming up that'll explain this a little bit more. All right, I think I covered the rest of this, Joe, already. Let's just skip through this one. All right, example number one. I probably need to update these examples because the rent amounts are probably too low. But in any event, contract rent for a subsidized apartment is $500, and that includes all utilities. The tenant makes $1,000 per month at her job. How much does the tenant pay, and how much is the subsidy payment? Now, don't skip to the next slide yet, Joe. Someone give me the answer, and let's see if someone can get the answer correct here.
Just so you know, Nick, I'm not in control of the slides.
Oh, who's in control? Oh, all right. Well, but you're in control of the questions, right?
I am.
Has anyone given us an answer yet?
No.
Normally, I call on people.
I understand. I do too. We have an answer, $300.
Okay, that's how much the tenant pays. That is correct, because $300 would be 30% of 1,000. How much would the housing authority pay, assuming this is a housing choice voucher, how much would the housing authority pay to that private landlord?
Even I can do this math.
No, I just saw $700. Is it what I'm seeing in my chat box? Is that what you're seeing, Joe?
Somebody had $200 though after that.
Okay. Yes, $200 is correct. Go to the next slide, please.
The 700 was subtracting from the income, not from the rent.
Yeah. So this is really hard. I kind of hate Zoom meetings for this very reason. Maybe we'll be in person next year. Who knows? But right. So the tenant share is 300 because that's 30% of 1,000. So then you take the contract rent and subtract the tenant share, and $200 is the amount of subsidy that's paid, or the housing assistance payment. So that seems simple enough. All right, next example. All right, the total rent for the subsidized apartment is $500, just like example one, but no utilities are included. The local public housing authority has determined that the average utility cost for this apartment per month is $100. The tenant makes $1,000 a month. So how much does the tenant pay, and how much is the subsidy in this example? Am I looking at the right thing, Joe?
So we have a bunch of answers that got uploaded because there were so many from last time. Nick, I think we need to skip the questions. We are pretty far behind. We only have 20 minutes left.
All right, well, just jump forward. Come on, I love these examples. Give me the next slide. Okay, so, oh wait, go back one. All right, so in this case, 30% of the income is $300. So that's the most the tenant should pay. But because their utilities are $100 a month, that gets deducted from their share. So the tenant is only paying $200 a month in rent, and $100 goes to their utilities, so that the housing assistance payment that goes to the landlord would be $300 because no utilities are included for this apartment. So it's different from the previous example. All right, Joe, we can skip example number 3. Maybe we're getting too inside baseball. Okay, for all types of wait, no, you can skip 3. Let's just go on. Even though I really love that example. All right, there's something called minimum rent in all types of subsidized housing. It's different for different types of subsidized housing. So for public housing, it can be $0 up to $50 a month. The PHA, the Public Housing Authority, has discretion from HUD to set that at whatever they want. Most public housing authorities that I'm aware of are doing a $50 minimum rent right now. Housing choice vouchers are the same way. They can have anywhere from a $0 to a $50 minimum payment per month that the Public Housing Authority gets to set when they administer that program. Project-based Section 8, I think this covers all different types of project-based Section 8, is $25 a month, and that was set by HUD. So keep in mind there can be different minimum rents based on what type of housing, what type of subsidized housing it is. One thing I would say is for any type of subsidized housing, there's something called a hardship exemption. So the person can ask to have even a minimum rent of $50 a month or $25 a month waived under certain circumstances. So for example, if someone is disabled and for some reason their disability benefits stop and they have no other household income, what they can ask for a hardship exemption and have that their amount of rent set at $0. If someone is not eligible for disability benefits but is unable to work because they have long COVID or something and had no income for for a few weeks and may not be able to go back to work for several months, they can request a hardship exemption and ask that their rent be set at $0. So it's just an important concept to keep in mind, more so than minimum rent, is that there is a hardship exemption to minimum rent, which the tenant can ask for in circumstances where they don't have any income at all, and if they can show some sort of good reason for that.
All right, we have another question. What if the tenant does not supply income or household composition by their yearly renewal? Do they receive more time?
Well, the answer is maybe. There are some regs that deal with this, and there is some more guidance in the HUD handbook of what to do if a tenant doesn't recertify timely. Now, the one thing you have to look at is whose fault is it that the person didn't timely recertify? So if the landlord forgets to notify the tenant because there's a change in management or something else, then generally the tenant is not responsible, and they have until the landlord meets their requirements to recertify. If the tenant ignores those recertification letters, which unfortunately sometimes tenants do, or if the mail is delayed or not delivered or stolen or whatever, the tenants can have a problem, because if you don't recertify, that can result in your subsidy being taken away and the rent going up to the market rent for that unit. So generally speaking, I think this applies to most types. If the tenant misses their annual recertification appointments, they still have at least 30 days to get in there and recertify. And if they do that within 30 days, assuming everything is their fault, I think they're still allowed to recertify. After that 30-day time period, I think it's mostly at the discretion of the landlord. And it's possible they may have to pay market rents until the recertification is completed. How does that sound, Joe? Was I close?
Yeah, I think so. Somebody opined, and I don't think this is correct, the tenant is given 4 months to supply the income info. If not completed in time, they can lose their subsidy. I don't think the regs are that generous, and I don't think they apply across the board evenly for all programs.
Yeah, I think the 4-month thing is, they have to get 3 reminders of their upcoming annual recertification. And those start at 120 days before the recertification date. So I suspect that might be.
I agree. I think that's what they're referring to.
Yeah.
So is the utility allowance reduced if utility assistance programs like PIP are available?
They're not, which can actually cause some interesting situations sometimes. Now, the only people who can get a utility allowance are people with very low or no income, because you're always going to probably have some share of the rent. But if the utility costs are more than what your share of the rent is, you do get a utility assistance check. And so that might be, if you have no income, that might be $100 a month in my example. And your PIP payment might only be $15 a month. So in that case, that very low income person gets to pocket some money each month. But since they have no income, I'm not going to worry about that too much. But yes, it is possible that you could actually get more money back than you'd owe for your PIP payment.
We have 15 minutes left, Nick.
All right, Joe, what do you want me to do next? Go to the next slide. All right, this is, oh yeah, I should cover this and then we'll go on to terminations real quick. Okay, what size unit do I get? The general rule is 2 people per bedroom. And generally speaking, children don't have to share a bedroom with an adult. However, the local housing authority have lots of discretion from HUD, so they just need to have some kind of a policy for how many bedrooms you get for how many people you got in the household. But that's the general rule: 2 people per bedroom. Only people who are on the subsidized list can live in the subsidized unit. This is really important at legal aid, or at least at my office. We call these the bad boyfriend cases. The only people on the lease are mom and the 2 kids, but there's some guy who answers the phone every time we call. You can't do that. The boyfriend has to be on the lease if that is his permanent address. Now, it doesn't mean you can't have guests. It doesn't mean you can't have overnight guests, but it does mean if that's the person's primary place they live, they've got to be on the lease. Let's see. The only other thing I would say is you do have the right to a reasonable accommodation if you're in subsidized housing to get an extra bedroom. Now, it doesn't mean just because you're disabled, you automatically get an extra bedroom. And at least in Cincinnati, that's kind of the word on the street. Oh, I'm getting SSI, now I get a 2-bedroom apartment. It doesn't really work that way. What you have to show is not only that you have some sort of disability, but that also you have the need for an extra bedroom. And the most common 2 examples for that are, 1, medical equipment. So if you have a wheelchair or a power chair or a lot of other medical type equipment you have to store, you can apply for an extra bedroom to store that medical equipment in. Also, if you require a live-in aid, so if you need someone to help you get out of bed and help you with other kind of basic daily functions, you can request an extra bedroom so that you can have a live-in aid who lives with you. Occasionally, we might also see this if you have like a child who's disabled and for whatever reason, part of their disability, they can't share a bedroom with anyone else. Sometimes you'll see that situation too. But so while there's that general 2-person per bedroom rule, if there's someone who's disabled in the household, there can be some exceptions to that rule as well, or even to the whatever rules the local housing authority sets. All right, but your rent is still based on your income. So if you got $1,000 a month and you've got 2 people in your household, you get a 1-bedroom apartment, your rent's $300. If you've got 8 kids and you're renting a 5-bedroom house and your monthly income is $1,000, you pay $300 for that 5-bedroom house. The size of the unit and the amount you pay in rent for subsidized housing are independent of each other. All right, next slide. Okay, there's 2 different topics I'm going to cover next in the next however many minutes I have. 16 minutes, is that right, Joe? No, 11 minutes. Ugh. Okay, there's 2 different things and they're different. You have different rights. One is applying for subsidized housing. So if you apply for subsidized housing and you get denied, you have certain limited rights to challenge that denial. These rights are not the same as someone who already is in subsidized housing or has a housing choice voucher and gets terminated. They have more rights. But what I want to say, just generally speaking, is if you apply and are denied, usually at a minimum, you're going to have the rights to meet with whoever made the decision to deny you and get a decision in writing. that being said, subsidized landlords are allowed to screen for things like credit history, criminal history, your history, your eviction history, history as a tenant, those sorts of things. So they are allowed to screen tenants and have fairly broad discretion. But if they're going to deny you, they have to generally notify you in writing and give you some right to be heard about that denial. All right, that was really short. How'd I do, Joe?
I just want to say for the record, the database that I mentioned earlier is the one that you have here highlighted for people, which is not only good for project-based Section 8, but also for LIHTC properties. Go on, Nick.
I was going to say, the one thing I like about this database, the Ohio database, is that it has contact information that I think is, well, it used to be fairly up to date. Maybe it's not anymore. But we used to send tenants here who are looking for subsidized housing because it would have the correct contact information for and the addresses of the different subsidized housing available around here.
Yeah, we do the same thing for that reason.
Okay. All right, next slide. I might have covered this slide already. All right, I think I covered this. Let's go on to the next one. Okay, this slide just deals with, so once you've applied and been denied, you have some rights to notice and some right to be heard by that landlord who denied your application for subsidized housing. A couple of topics that we see that people should keep in mind is there are very few mandatory denials. These are set up by federal regulation. One is lifetime sex offenders. So if you're not a lifetime sex offender, but you only have to report for 10 years, there's not a mandatory denial. Now, if your conviction just happened in the past year or two, they can still deny you based on whatever their acceptance policy is, but it's not a mandatory ban. The other mandatory ban, and this is very specific and very odd, are people who manufacture methamphetamines in subsidized housing. They have a lifetime ban. I guess if you manufacture other kinds of drugs that aren't methamphetamines, you're not automatically banned. Go figure, but that's what the rule is. The rule is that specific.
The feds don't like it if you're manufacturing drugs that blow up their property.
I guess, but make all the crack you want. I don't know. In any event, anytime any landlord says there's a mandatory denial of this person, chances are there isn't, because it's got to be one of these three things. Now, the other one that comes up a lot is current users of illegal drugs. That's not defined very well anywhere. I would say if someone, has multiple or extremely recent, in the past couple of weeks, drug charges, or maybe if they show up to the application meeting with a joint in their mouth, then you get to deny them. I don't know what current use means, but that's the only other mandatory denial. All right. Other than that, they just have discretion and they have to follow their written policy to decide who they're going to admit and who they're going to deny. And as I've said multiple times now, you always have some sort of process in a denial. Next slide. Okay. Termination. So what I'm referring to here is either an eviction or a termination of a subsidy for someone who is already in subsidized housing. That's the difference between an application and this sort of termination that I'm going to talk about next. To be terminated from subsidized housing, there must be good cause. I've got that in quotes because that's kind of a term of art that's defined by HUD in their federal regulations. One good cause is non-payment of rent. So if you don't pay your share of the subsidized rent, you can be evicted or have your voucher terminated. Serious lease violations or repeated lease violations. So it can't just be something small. If you play your music loud once, that's probably not a serious or repeated violation. If you play your music loud every night or every weekend and bug your neighbors, that might be seen as serious or repeated. But it can't be something that's just small, it's something de minimis. Unauthorized occupants. This is a big one for good cause. If the bad boyfriend is living there and he's working and you don't report that he lives there, and you don't report his income, that's something you can definitely be evicted for or get terminated for. Unfortunately, we do see that a lot. Failure to recertify. So if you get those 3 notices of your annual recertification and don't show up, that is good cause to terminate you from your subsidized housing. Some types of criminal activity or alcohol abuse, generally speaking, I shouldn't even say that. Usually they need to occur on or at least near your unit. Although for public housing, that's technically no longer true. But it should have to be serious criminal activity And frankly, to terminate someone's housing, it should affect the quality of life at the apartment complex or whatever. What we will sometimes see is if a landlord doesn't like the tenant and the tenant, let's say, picks up a shoplifting charge somewhere, they will try and evict the tenant. And what we would say is that's not good cause to evict them. That doesn't affect anything about the housing situation. All right, next slide. I think I covered most of this, but let me hit that second bullet point. The tenant must be responsible for the alleged conduct. And this kind of gets back to what we were talking about with VAWA. If someone's abusive, ex-boyfriend kicks in their door, that's not a lease violation by the tenant, right? That's the criminal act of a third party. So in that situation, that's not good cause to terminate the tenant, even though the door was kicked in. They need to go after the person who did that, and they can't blame the tenant for any damage that occurs on the property. The tenants do have some responsibility for the actions of their guests, but we have to, you've got to be clear on these types of terminations. The tenant is actually the person who's legally responsible for the conduct. I won't go into that too far, but that's an issue that we deal with in court a lot. I think I already said this, but good cause does apply to LIHTC, rural development, and other kinds of that fourth kind of other subsidized housing category that may not be income based. Joe, I see you unmuted. What did I miss?
Just saying that we have 4 minutes left. So.
Okay, next slide. Let's see how I want to do this. Okay, so for all different types of subsidized housing, when it comes to termination, there are different rules. So you have more protections in public housing than anywhere else, but you have some protections in any kind of subsidized housing. So this is I want to talk specifically about, or generally about, all types of housing. They have to give you a specific notice before they terminate your subsidy. It may have some specific language that has to be required under the federal regs. It must state the reason for termination, and it must state that reason with specificity. It's not enough to say you violated your lease on June 3rd and you know what you did. Even if the tenant does know what they did, that is not sufficient. They have to say something like, on June 3rd, you played loud music and the police were called. And when they got there, I don't know, your pit bull was smoking a joint. And so that's why we're terminating your tenancy. But it's got to be specific to what actually happened, what the good cause is to terminate the tenancy. The only thing they can terminate you for is what's in that notice. So if the reason they're terminating you is not listed in that notice of termination, it's not sufficient to terminate the subsidy. They must strictly comply with federal law. So if they put in some of the federal language, but not all of it, that's not good enough. They have to follow all the federal requirements strictly. One thing they can do is these notices can be combined with notices required under state landlord-tenant law. And since I only have 2 minutes left, I don't want to get into that. But just so you know, they are allowed in some instances to combine these two types of notices. All right, Joe, why don't I end there and see if we have any questions, unless you think there's any major topics I've missed.
Well, there are two pretty good questions. Some of one of which I waited because I thought you'd get to it, but you're right, we don't. Can you appeal if the housing authority denies you for Section 8 or public housing?
If they deny you, if you're an applicant, I would say probably not, but I'm probably missing some way when you can. If they try and terminate your voucher when you're in the program, there are definitely appeal rights where you can do what's called an administrative appeal to common pleas court. So there are some ways you can appeal to court, but generally, Joe has that look on his face. Maybe I'm wrong about this, but generally that's only for people who are actual participants and not applicants.
And you probably need a lawyer.
You definitely need a lawyer.
All right, before I forget, the code is HOC-MHN 22. Again, HOC-MHN 22. And I'm going to try and get one more quick question in before we go. because this is a good question. If a tenant in subsidized housing is being evicted, when does the subsidy end? When the tenant goes to court? When the bailiff comes to remove them from the unit?
I mean, when you're talking about a unit-based subsidy, public housing or project-based Section 8, I think the subsidy goes until they move out of the property, either voluntarily or because of a set out. I think that's right. What you can see with a housing choice voucher is that if they are terminated for some reason, that doesn't terminate their tenancy. So they can still live in the apartment, but if their voucher gets terminated for some good cause, then they're responsible for the market rent. So that, I don't know if that's what this question was getting at or not, but within the voucher program, it's possible that once you're terminated, you would owe the full market rent. If you can't pay that, your share of the rent can change in that way, I guess I would say.
I would suspect part of the reason for this question was because, and you've probably seen this too, where housing authorities jump the gun and terminate the subsidy well before the process is completed. And then you have to go, jump up and down.
Yeah, if you don't recertify on time and you're still there, that can sometimes be an issue, but it's a pretty limited circumstance. But yeah, I guess if you don't show up for your annual recert and don't recertify within 30 days after that, then I guess technically they can remove the subsidy and you're supposed to pay the full market rent for that unit.
All right, we are 1 minute over. I apologize, everyone.
Well, let me say this. I'm sorry for talking so long, but I'm glad we had all these questions because they're more interesting than anything I was going to cover.
No, your audience was definitely engaged. They obviously were very interested. So that's always a good sign, in my opinion. So more questions is better than no questions. So I agree with you.
I think my contact information is somewhere. Feel free to email me or give me a call if I missed anything important.
So, all right. I want to thank everybody for attending this session, for attending the conference. I hope you've enjoyed the conference. I know I did. We will hopefully see you all next year and definitely see you and not just see you on Zoom. So, but that's a discussion and a question to be answered for another day. All right, everybody enjoy the rest of your day. All right. Thanks,
Bye,
Nick.
everyone.